La Cour.
Please be seated. The sitting is open. The court meets today pursuant to Article 67 of the statute to deliver its advisory opinion on the request submitted by the General Assembly of the United Nations on the question of the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including Jerusalem. The questions on which the advisory opinion of the Court has been requested are set forth in Resolution 77/247, adopted by the United Nations General Assembly on December 30, 2022. By a letter dated 17 January 2023 and received by the Registry on January 19, 2023, the Secretary General of the United Nations officially communicated to the Court the decision taken by the General Assembly to submit these questions for an advisory opinion. Paragraph 18 of the resolution reads as follows, and I quote, "The General Assembly decides in accordance with Article 96 of the Charter of the United Nations to request the International Court of Justice, pursuant to Article 65 of the Statute of the Court, to render an advisory opinion on the following questions, considering the rules and principles of international law, including the Charter of the United Nations, international humanitarian law, international human rights law, relevant resolutions of the Security Council, the General Assembly, and the Human Rights Council, and the advisory opinion of the Court of July 9, 2004. A. What are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the Holy City of Jerusalem, and from its adoption of related discriminatory legislation and measures. B. How do the policies and practices of Israel referred to in paragraph 18A affect the legal status of the occupation, and what are the legal consequences that arise for all states and the United Nations from this status? End of quote. In accordance with usual practice, I shall not read out the introductory paragraphs of the opinion, which set out the main elements of the procedural history of the proceedings. I shall also omit or summarize some of the other paragraphs of the opinion. I shall accordingly begin reading the advisory opinion at paragraph 22. The full text of the opinion will, of course, be available at the close of the sitting. When seized with the request for the advisory opinion, the Court must first consider whether it has jurisdiction to give the opinion requested, and if so, whether there is any reason why the Court should, in the exercise of its discretion, decline to answer the request. The Court must satisfy itself, in accordance with the requirement of Article 96 of the Charter and Article 65 of its statute, that the question on which it is required to give its opinion is a legal question. In the present proceedings, the General Assembly put two questions to the Court. These questions relate first to the legal consequences arising from certain policies and practices of Israel as an occupying power in a situation of belligerent occupation since 1967. Secondly, they relate to how such policies and practices affect the legal status of the occupation in light of certain rules and principles of international law, and to the legal consequences which arise from this status. The Court considers that these questions are legal questions. In light of the above, the Court concludes that the request has been made in accordance with the provisions of the Charter and of the Statute of the Court, and therefore that it has jurisdiction to render the requested opinion. The fact that the Court has jurisdiction to give an advisory opinion does not mean that it is obliged to exercise it. However, only compelling reasons may lead the Court to refuse to give its opinion in response to a request falling within its jurisdiction. Some participants in the present proceedings have argued that there are compelling reasons for the Court to decline to give its opinion. As to the argument that the request relates to a dispute between two parties, one of which has not consented to the jurisdiction of the Court considers that the subject matter of the request is not only a bilateral matter between Israel and Palestine, but it is of particular interest and concern to the United Nations, and that giving the opinion requested does not have effect of circumventing the principle of consent to judicial settlement. As to the argument that the Court's opinion would not assist the General Assembly in the performance of its functions, the Court considers that it cannot substitute its own assessment of the need for such an opinion with that of the organ requesting it. As to the argument that the opinion of the Court would have an adverse effect on the negotiation framework, the Court considers that it is a matter of conjecture on which the Court should not speculate. As to the argument that the Court does not have sufficient information to enable it to give an advisory opinion, the Court considers that it has before it sufficient information to decide legal questions in a manner consistent with its judicial function. As to the argument that the questions are formulated in a biased manner, the Court does not consider that the General Assembly intended to restrict the Court's freedom to determine these issues. The Court will ascertain for itself whether Israel's policies and practices are in violation of the applicable rules and principles of international law before determining the legal consequences of any such violations. Having examined each of these arguments in turn, the Court concludes that there are no compelling reasons for it to decline to give the opinion requested by the General Assembly. The Court then recalls the general context of the case before turning to the scope and meaning of the questions posed by the General Assembly. In this regard, the Court notes that the questions define the material, territorial, and temporal scope of the Court's inquiry. With regard to the material scope, questions A identify three types of conduct, which question B describes as policies and practices of Israel. First, the ongoing violation by Israel of the right of the Palestinian people to self-determination. Second, Israel's prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the Holy City of Jerusalem. Third, Israel's adoption of related discriminatory legislation and measures. The specific scope of each of these policies and practices is determined later, as the Court examined them in turn. Before turning to that examination, the Court limits itself to observing a feature common to all of them, namely that the terms of question A assume that these policies and practices are contrary to international law. By virtue of its judicial function, however, the Court must itself determine the lawfulness of the policies and practices identified by the General Assembly. In the present case, the Court considered that question A required an assessment of the conformity with international law of those policies and practices of Israel identified in the request. The Court considers that in its request, the General Assembly has not sought from the Court a detailed factual determination of Israel's policies and practices. Therefore, in order to give an advisory opinion in this case, it's not necessary for the Court to make findings of fact with regard to specific incidents allegedly in violation of international law. The Court need only establish the main features of Israel policies and practices, and on that basis assess the conformity of these policies and practices with international law. In terms of its territorial scope, question A refers to, and I quote, the Palestinian territory occupied since 1967, unquote, which encompasses the West Bank, East Jerusalem, and the Gaza Strip. The Court notes that the various United Nations organs and bodies frequently make specific reference to the different parts of the occupied Palestinian territory. The Court also does so in the present advisory opinion as appropriate. However, the Court recalls that from a legal standpoint, the occupied Palestinian territory constitutes a single territorial unit, the unity, contiguity, and integrity of which is to be preserved and respected. Thus, all references in this opinion to the occupied Palestinian territory are references to a single territorial unit. The Court further observes that the question mentions measures pertaining to the Holy City of Jerusalem. The ordinary meaning of this term is ambiguous and may be subject to multiple interpretations, but the context provides useful clarification in the present case. In light of this context, the Court is of view that the question posed by the General Assembly relating to the Holy City of Jerusalem is confined to measures taken by Israel in East Jerusalem. In terms of its temporal scope, question A requests the Court to take account of measures adopted by Israel in the occupied Palestinian territory since 1967. However, the Court is not precluded from having regard to facts predating the occupation to the extent that this is necessary for the proper discharge of its judicial function. The Court notes that the request for an advisory opinion was adopted by the General Assembly on December 30, 2022, and asked the Court to address Israel's, I quote, ongoing, or I quote again, continuing policies and practices. Thus, the Court is of the view that the policies and practices contemplated by the request of the General Assembly do not include conduct by Israel in the Gaza Strip in response to the attack carried out against it by Hamas and other armed groups on October 7, 2023. Question B has two parts. The first part requests the Court to assess how the policies and practices of Israel identified by the General Assembly affect the legal status of the occupation. The court observed that the use of the verb affect points to the possibility that such policies and practices may bring about changes to the legal status. However, the scope of the first part of the question depends upon the meaning of the expression legal status of the occupation in the overall context of question B. In the present context, the Court is of the view that the first part of question B calls on the Court to ascertain the manner in which Israel's policies and practices affect the legal status of the occupation and thereby the legality of the continued presence of Israel as an occupying power in the occupied Palestinian territory. The Court observed that both question A and the second part of question B call upon it to determine the legal consequences arising respectively from Israel's policies and practices and from its continued presence as an occupying power in the occupied Palestinian territory. If and to the extent that the Court finds that any of Israel's policies and practices or its continued presence in the occupied Palestinian territory are contrary to international law, the Court indicates that it will examine the legal consequences following from such findings for Israel, for other states, and for the United Nations. Having defined the scope and